Thanks for inviting me here this evening. I'm just going to speak briefly about the GDPR 11 months in at this stage, nearly 1 year, even though we've all been talking about it for a lot longer than that and certainly thinking about it. So just to start, we recently published our annual report under the new office, the Data Protection Commission, that was established under the Data Protection Act 2018. And this is just a brief overview of some of the statistics that Brian mentioned also at the beginning. In terms of the volume of complaints, these are the ones up to date as of towards the end of March. We've seen a significant increase. Obviously, as compliance and awareness has been increased in the last year around GDPR, indeed for data subjects and for data controllers and data processors, there's been a simultaneous increase in complaints and breaches. The number of complaints, they mostly relate to subject access requests and the unfair processing of data. And in relation to the breaches, they mostly relate to human error, and that's associated with unauthorized disclosure, such as sending an email to somebody else by mistake with the wrong attachment, or losing your phone, or it's all human error. So it really links in then to the making sure of what somebody else said earlier about the policies and the procedures and the training, that you're building resilience throughout your company from the bottom up, and that people are aware of the small little things that can happen that will amount to a breach that maybe needed to be reported to the DPC. 7% of the breaches reported to date have related to cyber attacks, which is actually not that large when you think of the number of the big data-rich companies that there are, and they would relate to hacking, phishing, malware, ransomware, and software vulnerability. Just to recap on what GDPR brought into focus, of course, was the accountability requirements and for the data controllers and processors to demonstrate compliance. The increased transparency requirements, providing information at the point and before you start processing a person's data. The mandatory data breach reporting, the increased obligations around consent, that it needs to be explicit. I have a slide on that later on. Embedding and codifying data protection by design and by default. Of course, the enhanced and new data subject rights, the appointment of a data protection officer, and then in particular the administrative fines that are possible for infringement of the GDPR. That said, there's 3 key themes in the GDPR under which organisations were getting ready to be compliant or on their compliance projects for GDPR, and those were governance, accountability and transparency. Indeed, it was an opportunity for businesses at the time to invest in new technology, to increase efficiency, to have a look at the procedures and the processes in place around their data processing and their data management, and managing all of the risks associated with that, documenting and defining your processes and procedures, coordinating and aligning the processes and procedures right across all of the business units, ensuring that there's governance and control around those policies and procedures, and then educating and informing everybody in the company. And in terms of demonstrating compliance, it's very important for our office when we engage with the data controller. And having a strong foundation of governance there will allow you to take a practical approach in terms of fulfilling your obligations under the various articles that under which you have to demonstrate your accountability. Maintaining up-to-date inventories of processing, completing data protection impact assessments, and that's really important. It was mentioned earlier, particularly in this day and age when companies are so innovative and there's a lot of new products, and it's not only new products, when there's a change to the product or an update to it, that impacts the processing of personal data. You should screen it to ensure to check whether you need to do a data privacy impact assessment to assess what risks there may be. And Documenting the screening procedure for the DPIA is important as well, and documenting why you're not undertaking a DPIA and the decision-making process around that is also important to show to our office. Should there be any concerns or issues arising with the new product, we will look and see if there's a DPIA has been undertaken. Looking at your Article 28 agreements with data processors and determining who's the data controller and who's the data processor, this has caused a lot of challenge, I understand, in the last year with companies, and it's something that the European Data Protection Board are looking at as well in terms, and later this year we'll be bringing out guidance for data controllers and processors on that. The embedding privacy by design and privacy by default from the outset, the womb to tomb of the data processing, it's necessary to have everybody around the table when you're developing your product, your security guys, your engineers, your privacy team, making sure that at the very start the privacy elements of the project are considered, and this will allow you to identify and eliminate risks early on. In terms of, I mentioned the controller and processor relationship, it's really important that you have a mechanism for monitoring and managing that relationship, and it's something that we do look at if there are concerns or issues brought to our attention, and having a strong contract an agreement in place that would allow you as a controller to undertake audits on the processing procedures that you have procured through the company, inspections, that there's follow-up actions, that there's regular reviews and spot checks. Transparency requirements. This was another thing. Everybody was reviewing their privacy policies and making sure that they're absolutely conspicuous and clear, and that there's clarity around the lawful basis under which you're processing the data, that the language is clear, you're avoiding ambivalent terms, that you're being very explicit and not saying, for example. We've also found it, we've got some feedback as well, it's useful, particularly where there's a change to the process and you're updating your privacy policy, it's useful in some cases to state explicitly what you're not doing with the personal data. Because there's an assumption sometimes on the part of the data subject that you might be doing something with my data. So being as clear as possible. Then of course, consent, and if at all possible, try and not rely on consent, which of course you have to do if you're processing special category data. But if you are relying on consent, as it's defined, it must be absolutely clear, unambiguous, freely given, and it cannot be relied on where there's an imbalance of power, for example, in employment contexts. Another challenge or pressure point that has come to light in the last year in particular is around the breach notification to the DPC. And there is mandatory requirement unless that the breach is unlikely to result in a risk to the rights and freedoms of the natural persons. So how do you determine the risks associated with that? You look at your security mechanisms in place. Data security and data privacy have a symbiotic relationship. It's necessary that, and as codified in Article 32 of the GDPR, that you ensure that there are appropriate and really strong technical and organisational measures in place to provide security of the data processing that's taken place in your organisation, and that you build resilience around that you test it time and time again, and that you can demonstrate this. And if you are absolutely assured around the data security, and it'll mitigate against the risk of the disclosure or the loss of control over the data arising to a breach, then you may not have to report it. It's important as well in terms of data breach notification that you pay close attention to your upstream and downstream suppliers and partners, and where you have an outsourced data processor and they have a breach, that there's a mechanism that they have they can inform you in a timely manner as well to allow you report the breach and manage it if necessary. And as again, what I mentioned earlier, the majority of the breaches that have been reported to us are as a result of unauthorised disclosure. It doesn't necessarily mean that the data was extracted. If you've lost control of the data and it's disclosed in any way, you need to be able to prove that it hasn't been extracted. If you've left the door open, it's still possible for somebody to get in, so it may be a breach. And then when to communicate the data breach to the data subject. This, again, it's when it's likely to result in the high risk to the rights and freedoms of the natural persons. Our office may determine that because of the nature and gravity of the breach reported that it's necessary for you to communicate it to the data subject, or you may have indeed decided yourself based on your policies and procedures that you report breaches. And in terms of the key deliverables for data controllers and processors in their ongoing journey with compliance to GDPR, it's ensuring that you're reviewing and documenting the legal basis for all of your processing at any time. Reviewing and remediating storage and retention practices in particular. Maintaining your Article 30 records of data processing is very useful. It will also allow you to see, or when you're undertaking an audit, what data you're collecting and why, and is it still necessary? Again, as I mentioned earlier, with innovation, we've got huge capacity to gather and bring in loads of data into the company, but you need to be absolutely sure that you're only gathering what you need. Updating your privacy notices, reviewing and refreshing databases and mailing lists, reviewing your data security practices, identifying and reviewing all of your third-party processors, embedding a practice and procedure of privacy by design and privacy by default, and reassessing your breach notification procedures. And also not listed there is having the procedure to adequately service subject access requests. That's one of the, as I mentioned earlier, the highest rates of complaints relate to subject access requests, and in some cases it's because the organisation can't meet the 30 days, or they can partially meet it, or they haven't fully met the requirement because the systems and procedures don't allow them to extract the data efficiently. Some key priorities for our office this year, we're progressing a number of inquiries. We've 50 statutory inquiries open. The first decisions are expected in the summer this year. We continue to supervise and engage, in particular with the big tech companies that are based in Ireland. We've increased our staff up to 136 at the moment, and there'll be another 30 joining the team throughout this year. We're increasing our capacity in terms of technology, given the number of big tech companies that are in Ireland. We need to have the capacity in-house to assess and respond to all of the material coming in from those. We're currently undertaking a consultation in relation to the rights of children as data subjects. That's finishing up tomorrow. That was a public consultation. We're establishing a 5-year regulatory strategy under the GDPR and the Data Protection Act. We're putting in place a DPO network in the various sectors that will be able to, and this is part of our awareness program, where we can go out and meet with them on a regular basis and learn and share what the challenges and pressure points that people are experiencing. And then in terms of issuing guidance, as I mentioned, the EDPB are looking at, and we sit on various subgroups under the European Data Protection Board, and we're looking at data controllers and data processors and joint data controller relationships, machine learning and artificial intelligence and the increased use of that, and biometric data processing. So, thank you. I hope you found it useful.